Welcome to the session that will provide an update on legal issues connected to the COVID pandemic. Before we start, I want to acknowledge that we are on the shared territories of the Coast Salish people, the Musqueam, Squamish and Tsleil-Waututh nations.
So welcome everybody who's there. We're happy to see you at what, if this were the real life conference, would be our first plenary, and we'd all be sitting there in the big room and getting updates on things that have happened in the past year. So we're happy to see you here virtually. We have Allison Ward from class, Kevin Love from class, and Michelle Beda from TRAC, who are going to be giving you updates. I will leave them to give brief introductions of themselves when they speak. I think the main things we want to let you know today are just to remind you to do questions in the Q&A, and that we will be doing questions at the end of the session because there's quite a lot for each of the speakers to cover. Okay, that said, I'll just hand it over to Allison, who will be starting the session.
Hi, everybody. It's really wonderful to be here today. This session, like Lois said, is usually the opening plenary of the 3-day live version of the conference. So it feels to me a little bit like the start of conference, and I'm happy that we're able to at least do it remotely this year. So my task today is to do a welfare legislative update since the conference was held last year in October. Before I do that, I will just introduce myself briefly. I'm a lawyer at the Community Legal Assistance Society, and I operate the Community Advocate Support Line. I've worked at class since 2010, and prior to that, I was a staff lawyer at the Legal Services Society. So I have prepared materials for today, and I have uploaded them to SCED, so you can find them there as a PowerPoint, which I'll also be sharing today. When I started preparing the materials, I thought there weren't that many updates to go through this year, but as I put the materials together, I gradually realized that there were far more changes than I originally thought. The theme of the workshop today is advocacy in a time of COVID. So what I'm going to be doing is, first of all, reviewing some of the COVID-19 related changes to welfare law and practice and procedure, and then going over some non-COVID, non-state of emergency related changes that happened this year. There we go. So we're going to start with COVID-19 related changes. I'm going to go through this material quite quickly. This is really intended to be a high-level overview of changes, just touching on the basics so that you have an idea of what has changed this year. I included quite a bit of detail in the PowerPoint slides so that you'll have them available for reference in the future. And as Lois said, I am teaching a couple of other welfare-related sessions in the conference, and we'll have more opportunity to answer questions there. So please feel to put your questions in the Q&A boxes, and we'll get to them hopefully at some point. And with that, I'm just going to move right into things. So with COVID-19, there have been various types of benefits that have been exempted by the ministry as both income and as an asset on a temporary basis. So I'm going to move through those. Some of them are no longer really applicable because some of the benefits, like the Canada Emergency Student Benefit, for example, has already been fully dispersed and is no longer in pay. But I'm going to review them one by one. So first, as of June 18th, there was an exemption for any amount of assistance in relation to the COVID-19 emergency provided either by an Indigenous nation or an Indigenous organization that provides services to Indigenous individuals. And that is exempt for all purposes from all forms of welfare benefits. And as I said, there's no dollar cap on those amounts. So that's a complete exemption for welfare's purposes. You'll see on my slides down the bottom, I've included legislative references to source all of the information that I'm sharing. So as you print off the PowerPoint from SCED, hopefully those references will be helpful for you in the future. We also had a exemption of a federal one-time payment that some seniors received. All of those funds were paid out by September 30th by the federal government. So this exemption still exists in the regulation, but everybody who is eligible for the benefit should have already received it, and it would have been exempted. It was $300 for seniors eligible for old age security in June of this year, with an additional $200 for seniors eligible for GAS. Similarly, the federal one-time payment that is being paid to some people with disabilities is fully exempt as both an income and an asset for all forms of welfare. Payments of the federal benefit are expected starting this month. And it is a federal payment paid to people on CPP or Quebec disability benefits as of July 1st, receiving a disability support through Veterans Affairs Canada as of July 1st, or who were either eligible for previously or applied for the disability tax credit by September 25th of this year. So I know that there were many people who tried to apply before that deadline. I don't think everybody who wanted to apply was able to complete those applications, but that deadline has now passed, and those recent applications for the disability tax credit are now being processed. I mentioned before there was an exemption of the Canada Emergency Student Benefit, which has now been fully paid out. It was paid from May 10th to August 29th only, so there will be no further payments under that benefit, but we do find in the regulations that there was a full exemption of the benefit as income and as an asset for people who were on income assistance, hardship assistance, or disability assistance as of May 1st, and who also met the eligibility criteria for the emergency student benefit. Many of you will be familiar, I think, already with this exemption, which is to some extent past news as well, because CERB is now transitioning to the Canada Recovery Benefit, but of course the exemption of EI may still remain relevant. So as of May 11th, the ministry temporarily exempted EI benefits. This would be both regular and sickness benefits, and Canada Emergency Response benefits as income and as an asset for some people receiving welfare benefits. The litmus test for whether those benefits were exempt are whether the person was receiving income assistance, hardship assistance, or disability assistance on April the 2nd, 2020. Initially, the exemption was for a 3-month period, but that was extended in July. And the exemption of EI and CERB now expires on March 1st of next year. We'll see if that is further extended as time goes by. Which brings us to the new Canada Recovery Benefits. And now Kevin, when he presents his portion of this panel, is going to be talking about eligibility criteria for Canada Recovery Benefits, among other things. So as he talks about that, it's important for you to know that Canada Recovery Benefits are, the ministry says, going to be exempt as income and assets for some people who are receiving welfare. So the test again is whether the person was receiving assistance on the same date as CERB, April 2nd, 2020. And here we have the addition that, the additional eligibility criteria that people who had the PWD designation on April 2nd may be eligible to have Canada Recovery Benefits exempted, even if they aren't receiving disability assistance on April 2nd. So there's not a lot of clarity on this point yet. The legislation to support the exemption isn't released yet, and neither is the policy. So I've got some questions into the ministry. I haven't had any answers yet. So as we learn more about this exemption, I'll be sharing that information on the POVNet welfare list. So if you're not signed up for the POVNet welfare list, I'll put in a bid for you to sign up for that. And I'm sure throughout the presentation today, we'll be giving information about how to sign up for POVNet lists if you haven't already done that. So we've gone through the exemption of various federal benefits that people on assistance may be eligible for. There's a category of people, of course, that are not eligible for EI or CERB while they're on welfare. And for those folks, there is a monthly COVID-19 supplement of $300 per adult in the family unit. That has been added to welfare audit checks automatically each month since April. And currently it is payable until December of this year. So the December check in late December for the January 2021 benefit month at this point is the latest announced $300 COVID supplement. And that supplement is available to people on all forms of income and disability assistance, as well as people receiving comforts allowance. That's people in special care, including alcohol or drug treatment, and also people who receive the BC Senior Supplement, which is a top-up of money from the ministry for seniors who are low income. It's available to most people, for example, who receive the Seniors Guaranteed Income Supplement. But it's a bit complicated to explain. So most, but not all people on GIS would be eligible for the BC Senior Supplement and then should be receiving the COVID $300 supplement from the ministry as well. And I've noted that this supplement is not found in the welfare legislation. It's provided under emergency response powers, and so is not subject to reconsideration and appeal under the welfare legislation. It's paid out as part of the ministry's emergency disaster supplement, which is money that the ministry can make available generally where there has been a declaration of an assistant deputy minister. So I'm going to turn to that topic more broadly now. So we have the specific supplement that is $300 per adult that has been sort of deemed the level of assistance that is issued under that crisis supplement as a given. It is still possible for folks on assistance who need additional monies because of the COVID-19 emergency and state of emergency to ask for additional emergency disaster crisis supplement monies from the ministry. Again, this is money that is not provided under the welfare legislation. The ministry administers the money, but it is provided under emergency response powers. So there is no dollar cap on the amount that could theoretically be available as a general emergency disaster crisis supplement. And it is available to people who are on income or disability assistance. And I've underlined medical services only here because folks on medical services only, which could include, for example, somebody who was on PWD benefits, but then started to receive CPP disability benefits above the PWD rate, that person would remain on medical services only status with the ministry. And they would not be eligible for the $300 a month COVID crisis supplement, but they would be eligible to apply to have a general emergency disaster crisis supplement if they have additional costs as a result of the pandemic and state of emergency. Also, folks who receive child in the home of a relative benefit, which is an old grandfathered benefit that can no longer be applied for hardship assistance. And I've outlined the eligibility criteria for this crisis supplement in the next slide. So the criteria are essentially the same as general criteria for a crisis supplement. The person needs to have an unexpected expense or an expected need for an item due to the identified emergency. They have no other resources available to meet the expense or get the item, and failing to meet the expense or get the item would result in imminent financial loss or danger to their physical health. And if the person is found eligible for it, the least costly way to meet the need will be authorized. Early on in the pandemic, the ministry was, I think, issuing a standard $100 a month to people who applied for this general supplement. The ministry, I haven't seen them sort of advertised since then, since the $300 supplement was introduced, that this is actually still available. So just note that it is. So if you have clients with additional expenses that they have no other ways of meeting as a result of the pandemic, bear this in mind, and you might want to make an application on their behalf. So with COVID-19, the ministry has also taken additional steps to minimize the need for in-person contact, either between clients and ministry staff, and some changes were made that advocates really pushed for to try and facilitate remote work by advocates in situations where we're not really able to meet in person with our clients. So important in founding sort of the basis for all of this was a ministerial order made April 28th. And importantly, it provided that any requirement in the welfare legislation to provide information or to sign a record or agreement could be done verbally. So that ministerial order has now been incorporated into the COVID-19 Related Measures Act, and it's scheduled to be in effect until 90 days after the current state of emergency expires or is canceled. Of course, that date could change. It could be amended at any point in time, but that's the current scheduled repeal. So examples of things that are facilitated by this provision in the original ministerial order are monthly reports can be completed by phone. The consent to disclosure or release of information form can be completed over the phone with the ministry worker. In that situation, the ministry sends the client forms to sign and return by mail to the ministry in the following 30 days. I'm sure most of you have probably gone through situations with clients where they've authorized disclosure of information to you by the ministry over the phone. And additionally, applications for assistance can be done by phone. Signing up for direct deposit can be done by phone with a ministry worker under the ministerial order, again, with documents usually to follow, to be mailed out to the client and the client to mail them back to the ministry. But in the meantime, the ministry will just act on that verbal authorization alone. Another step that was taken to minimize the need for in-person contact is that application forms for the persons with disability designation and the designation as a person with persistent multiple barriers to employment were both temporarily made available online. I've got the URLs there, taken from DABC's site. So thanks you guys for putting those up. They are still available online, and that is to facilitate remote completion of forms by doctors and clients, and of course yourselves as advocates, because usually those application forms have to be obtained directly from the ministry by the client. In-person contact has also been minimized in the sense that ministry is still continuing to waive the 3-week work search so that people don't have to go out and go for interviews, apply for jobs. Work BC centers are, however, open, and employment plan compliance is also currently waived. I know the ministry is sort of reviewing, I think, both of those points, and we may see some changes coming up in the future, but nothing has changed so far as I'm aware, on either of those points. There have also been COVID-related changes at the reconsideration branch, and in the next slides, I'm going to talk about reconsideration branch and also COVID-related changes at the Employment and Appeal, at the EAT, Employment and Appeal Tribunal. So first, turning to the reconsideration branch, the branch has a duty to comply with administrative fairness, and in accordance with that duty, the branch has been waiving, extending, or suspending deadlines where someone's been unable to meet a deadline because of reasons related to the COVID-19 emergency or state of emergency. So I really encourage you, if you're assisting a client with a reconsideration and they maybe have already missed a deadline, or they know that they'll be unable to meet a deadline that's coming up for maybe their quarantining, self-isolating, or maybe they need medical evidence that a doctor's not able to provide in time because the doctor's overburdened or unable to meet with the client in person because of the pandemic, please call or email the reconsideration branch and ask for exceptions to be made. And I think the reconsideration branch has been quite good about making exceptions in most of the cases that I'm aware of. However, where deadlines are extended, it's important to note that the effective date of a reconsideration decision can also change. So if someone's reconsideration request is late or a deadline for evidence is extended beyond the usual deadlines, the effective date of the reconsideration decision will also be extended. So if the usual deadlines aren't met, and as a result, the reconsideration decision is issued later than it is normally required to be issued under the legislation, there will also be a delay in the effect of the decision. So if the decision is in the client's favor, and as a result of the decision, the client is awarded a supplement or is found eligible for income assistance or disability assistance, then in that late situation, the reconsideration decision is going to take effect 30 business days after the person's notified of the decision. And again, I've got the legislative references for that information there for you. So turning now to the Tribunal, the Employment and Assistance Appeal Tribunal has also had changes related to COVID. Currently, in-person hearings are not being held, and all hearings are currently being held either by phone or in writing. Now, the Tribunal was given some special powers under another ministerial order, numbered 98, which was made April 22nd. And it provided that basically all tribunals, including the EAT, can waive, suspend, or extend a deadline related to an appeal. So based on that power, the Tribunal has been trying to accommodate situations, again, where somebody has missed a deadline due to COVID-19 or due to situations related to the state of emergency. So again, if you have a client who's in that situation of, having missed a deadline or likely to miss an upcoming deadline, please call or email the Tribunal as soon as possible and speak with Tribunal staff or the appeal coordinator assigned to the file to discuss. I think they've been making their best efforts to accommodate as well. And I'm just going to back up for 1 second and say that both with respect to the reconsideration branch and the Tribunal, I've heard from both that volume of reconsiderations and appeals has really fallen since March. There's about a 50% drop in reconsideration requests and a 50% drop in appeals being heard at the Tribunal as well. So the reasons for that, I think, are not clear. Whether it's that clients have had access to some additional benefits and are not needing to pursue issues they may otherwise pursue, or perhaps it's that the situation has made it very difficult to access advocacy services or to pursue communication with the ministry, and recons and appeals are maybe just not being filed. I don't know, but we have seen that drop in volume at both levels. So that brings me to the end of the COVID-related changes with respect to the ministry. So I'm going to spend some time now going over non-COVID-19 related changes. When I looked back over the year, we had a whole bunch of changes that took place on January 1st of this year. And one important change that didn't take place January 1st, which is what I'm going to turn to first. So as of November 4th last year, We've had the exemption as both an income and an asset of Indian day school settlements and 60 scoop settlements. Both are exempt as both income and as an asset for all forms of welfare. So what that means is somebody who receives a settlement under either of those programs needs to report it to the ministry if they're on benefits, but it should not have any effect on their ongoing eligibility for any form of welfare. So that exemption was actually the only change, non-COVID change, that didn't take place on January 1st. All of the other changes were effective January 1st. Some of the January 1st changes we expected because in the budget last year and the poverty reduction strategy last year, the government had announced 14 changes it planned to make to welfare law. And so I remember at conference last year, we went over some of the expected changes for January 1st. And at that time, we'd been told of 6 changes that the ministry thought it would be making January 1st. So those 6 changes were in fact made, the ones that had been anticipated, and I'll review those quickly. But there were 4 or 5 other changes announced or made effective January 1st that hadn't actually been announced previously by the ministry. So I'm going to start going over those because I think they're the ones that might be more unfamiliar to folks. So importantly, there is now more discretion available to the ministry in applying Section 10 information and verification sanctions. So Section 10 is a section that enables the ministry to ask somebody on benefits or even applying for benefits to supply more information or to provide verification of information that they've already provided. That can lead to a lot of difficulties where a person may not be able to obtain verification of something that the ministry is looking for. They may have practical difficulties. They may have mental health barriers, cognitive barriers. And before January 1st, if the ministry decided somebody hadn't complied with Section 10 and hadn't verified information that they wanted verified, the ministry's only option was to declare that person's family unit ineligible for benefits until the person provided the verification that they'd asked for under Section 10. So that was a very draconian consequence for many people, and some people were cut off under Section 10 and remained off benefits for a very long time. So importantly, as of January 1st this year, the ministry has 2 new options under Section 10. So first, instead of cutting a family unit off completely, it can simply reduce the amount of income assistance or hardship assistance, and I should add, or disability assistance, by $25 per calendar month until the Section 10 direction for verification is complied with. So $25 a month reduction, or the other choice available to them now is to kind of do nothing. So it's very clear now that if the ministry is satisfied that the family unit is homeless or at imminent risk of becoming homeless, the ministry no longer has the ability to declare the family unit ineligible for benefits. I suppose in that situation, they could still consider a $25 reduction, but I think there's room to argue that in that kind of situation, the ministry should exercise the discretion to take no action as a sanction under Section 10. I think another positive change this year is that more forms of hardship assistance are now not repayable. So the 2 categories are, so normally if you receive hardship assistance because you have more income than the legislation normally allows or more assets than the legislation normally allows, in most situations, the ministry sees that as kind of a repayable loan, and the ministry will require your family unit to pay that money back to the ministry. So the change here is that if using that excess income or trying to sell the excess asset would put someone in the family unit at risk of domestic violence, the hardship assistance is no longer repayable. So for all the family law advocates attending, you want to really flag this, because a quite common situation is a couple separates, one partner stays in the family home, it's in joint names. The ministry says, oh, it's, you have to sell you have to sell the asset. And that can create, I think, a risk of domestic violence in a number of situations. So good to be aware of that. The other situation where hardship assistance is no longer repayable is where someone is in a special care facility, either because they require extended care or in a drug or alcohol treatment center. That hardship assistance is simply no longer repayable. And again, I have the legislative references there for you. There's also been a change in how the ministry can collect, I call them ministry debts here. So that includes overpayments, where, for example, somebody received benefits that they weren't entitled to and has to pay them back, or deposit debts, which are defined to include security deposits, pet damage deposits, and utilities security deposits, and offense overpayments, which are overpayments that arise where somebody has been convicted of an offense under the employment and assistance legislation or under the criminal code in relation to welfare benefits. So what's changed is now there are only 3 categories of debt repayment amounts. If you have only an overpayment, it's going to be repaid $10 a month, deposit debts at $20 a month, and offense overpayments at $100 a month. Again, the change is that only one type of repayment amount can be collected at one time. And for example, it doesn't matter if you have, say, 2 or 3 security deposits out, the maximum deduction for the deposit debt is $20 total, not $20 per security deposit debt. The legislation is clear that the ministry cannot request more than those set repayment amounts, although a client can volunteer to pay more if the client wants to clear a debt, for example, more quickly. I think a really interesting development is that the ministry has now got a discretion not to make deductions for ministry debts in a couple of situations. So, where the ministry is satisfied that a family unit is homeless or at risk of becoming homeless, or that a deduction for the debt would result in danger to the health of someone in the family unit, the ministry can decide simply not to make any deductions for overpayments, deposit debts, or offense overpayments in those situations. And again, we see a provision that applies to people in special care, whether the person's in special care for extended care or alcohol or drug treatment. The legislation is clear that no deduction shall be made for any of the 3 categories of debt. I've got one more topic before we move on to the 6 things that had already been announced last year. So I'm going to spend some time on this, and then in view of the time, I think I will probably leave you to go over the slides for the 6 changes that had been previously announced and that were reviewed at conference last year. So for our last topic, we had a change January 1st again that was not expected, and it is to do with the test that applies when the Employment and Assistance Appeal Tribunal is deciding whether new evidence can be admitted. So this is evidence that was not provided with a request for reconsideration and was not before the reconsideration branch when it made its reconsideration decision. So prior to January 1st, the tribunal could only admit basically evidence that was in support of the information and records that were at the reconsideration stage. It was quite a limited test, and advocates often had to make arguments at the tribunal about whether or not a particular document could be, say, a new medical report, whether that could be admitted by the tribunal as new evidence. Well, good news. The test for admission of new evidence has been relaxed. So the tribunal can now consider evidence that is not part of the record. So evidence that was not at the reconsideration branch when it made its decision. So such evidence not part of the record as the panel considers is reasonably required for a full and fair disclosure of all matters related to the decision under appeal. So as long as the evidence that you want to submit to the tribunal is reasonably required, so for the issue at the tribunal to be fully and fairly considered, I think you can argue that you have a good basis to have it admitted to the tribunal. So if you look at, so the tribunal has a website, and on its website they have guidelines for members of the tribunal, and they've updated the guideline they have for members about considering new evidence. And I've included a quote from that there because I think it's quite important. So it's, when new evidence is admitted, the appeal is not strictly a review on the record below, but rather a review on the basis of all admissible evidence. So if the tribunal admits new evidence, the tribunal has to ask itself whether the decision under appeal was reasonable based on all of the admissible evidence, including any new evidence the tribunal has admitted. So while there's been no change in the test that the tribunal has to decide in determining whether to uphold the reconsideration decision or overturn it, I think this really broadens the situations where the tribunal is perhaps likely to overturn a reconsideration decision. So prior to this change, because it was more difficult to have new evidence admitted at the tribunal more often asked itself whether the reconsideration decision itself was was reasonably supported by the evidence that the reconsideration officer considered. And I think now it's clear in the guideline that the question for the tribunal where there has been new evidence admitted is whether the decision was reasonable based on all of the evidence both at recon and the evidence that the tribunal has before it. And I also just wanted to note that there was a legislative change making Section 40 of the Administrative Tribunals Act applicable to the tribunal. And, that took effect January 1st as well. And it's a bit of a technical point that I don't want to go too far into, but Section 40 of the Administrative Tribunals Act essentially supports this broadening of the tribunal's ability to accept information that it considers relevant, necessary, and appropriate when deciding on an appeal to the tribunal. So I think I'm just about at my time. As I said, I've also included in the slide 6 other changes that we reviewed last year at conference and that we had anticipated. I'm going to just flip through them in about a minute, just outline them for you, and then you can read through those slides yourself. So we had a change in the definition of spouse. So it used to be that the ministry could consider two people who were not married and who did not agree they were spouses. The ministry could previously consider them to be spouses once they lived together for 3 months. If the ministry thought they were living in a marriage-like relationship with social, financial, and familial dependence or interdependence, that cohabitation period has now been increased to 1 year. So you have to have lived together for 1 year, and the ministry has to be satisfied it's a marriage-like relationship with social, financial, and familial dependence or interdependence before you can be deemed to be spouses by the ministry under the legislation. There was a related change in the definition of dependent. Previously, dependent, somebody could be considered your dependent if they demonstrated a parental responsibility for your child. So it was a backdoor way to try and have somebody considered a spouse through childcare. In any event, that has now been eliminated from the legislation. So now dependents only include your spouse under the new definition and your dependent child if they live with you. There's been a change in shared custody situations, especially for the family law advocates out there. In a 50-50 situation, the change is that if only one parent receives welfare, previously, even if only one parent received welfare, the child was, the parent on welfare could only receive benefits from the ministry for that child if both parents agreed in writing that the child would be that parent's dependent child for the purposes of welfare benefits. So if only one parent receives welfare, currently, the legislation deems a child to be the dependent child of the parent receiving welfare. So the other parent doesn't need to agree in writing anymore to designate that person as the dependent child. If both parents receive welfare, there is no change. Here, the parents need to agree in writing as to which of the parents is going to have the child as their dependent child for the ministry's purposes. As we expected, the 2-year independence test ended on January 1st. So now you can qualify for welfare without showing any prior or employment or educational history. I think that's a fantastic change. It was anticipated. And the relevant provisions of the legislation that provided for that test have now been repealed. Again, as anticipated, the requirement to apply for early CPP retirement benefits has ended. For people who are 60 to 64, they're no longer required to apply for early CPP when they're on welfare benefits, and that means they'll receive their full CPP pension when they turn 65. We had an increase in crisis supplements for housing-related costs. The change is that crisis supplements for housing can now be issued up to a family unit's full monthly benefit rate, so their monthly rate for shelter plus support, whereas previously a crisis grant for housing-related costs was limited to the family unit's maximum shelter rate. We have some supplements that were previously only available to people on regular income assistance or disability assistance have now been made available to people on hardship assistance. So there's 2 slides reviewing these supplements. I'll leave you to read those yourselves. And as expected, we had a change in security deposits and pet damage deposits. Before January 1st, the ministry could not provide a pet damage deposit. It now can. If that deposit is required under the Residential Tenancy Act or required by a housing co-op, and there's no longer any limit on the number of repayable security deposits the ministry can issue to a family unit. Previously, it was usually limited to 2. And those were the 6 changes that we reviewed last year that we expected, and that is the end of my presentation. So I'm going to turn it over to Kevin, who is going to talk to us about the Canada Recovery Benefit and all things EI and CERB related.
Thank you, Allison. Everybody can see that okay? Well,
Yep.
Everyone else is muted, so guess they can't tell me, but Lois, you can see that?
I can see it.
Outstanding, great. And I hope the background noise isn't too bad, folks. My neighbor has decided that now would be a good time to fire up his chainsaw in the middle of the city. I have no idea what he's cutting, but I hope it stops for a whole host of reasons. Okay, so we're going to change focus a bit here, and what I am going to hope to cover. Allison has covered off a lot of the changes with provincial benefits. I'm going to flip and talk a little bit about the benefits from the federal government, the government of Canada. As most of you know at this point, this has been a bit of a journey. We came in with only EI, then we had the Canada Emergency Response Benefit. That went through a whole host of changes. Now that's wrapped up and EI is back, and we also have new recovery benefits. So rather than go through the whole year and talk about all the changes, I'm going to just fast forward to give you a snapshot of where we are now, because that's going to, I think, be the most useful to you. So the key changes we are dealing with now, number one, is that there's been a number of EI changes that makes EI much easier to get. So a lot of your clients who were not working or doing, or more correctly, were doing very small amounts of work and may not have had an EI claim are now quite possibly going to be EI eligible. Also, as Allison alluded to, the Canada Emergency Response Benefit, and from here on in, I'll just call that CERB. I think most people are familiar with it, has been phased out and replaced by a number of different what we call recovery benefits, which share some features of CERB, but also have a number of key differences. So what I hope to do is start by going through what this new and improved EI system, at least temporarily, looks like. And then for people who are still not EI eligible, go through what some of the recovery benefits are going to look like. So as I mentioned, CERB is done, and I put there sort of, it is done, but the government is still taking applications for the final CERB period. As people who are familiar with CERB will know, it generally ran in 4-week blocks, and the last block is still open for application. It's really unclear. A lot of this they're making up as they go along. It's really unclear why they're only taking applications for that period now and what the deadline is. I think the legislation says that the whole thing is supposed to wrap up by December 2nd. But the key takeaway here is that although we're going to spend most of our time looking forward at EI and the new recovery benefits, do remember that if you have clients who haven't made applications, especially for that last CERB period, they can still do it and get their money for that period before the new program takes over, which starts after September 27th. So as I mentioned, EI kind of, when the idea conceptually was when they brought CERB online, the idea was kind of to put EI on hold. The EI system was completely overwhelmed. We know now that EI was completely ill-equipped to deal with this kind of mass unemployment, and that we knew, but this really highlighted that just way too many workers are not eligible for EI. So EI just wasn't a tool they could use to really deal with the mass unemployment that was starting to hit as a result of the COVID-19 pandemic. So the idea was, okay, we're kind of going to put EI on hold. We're going to bring in this whole CERB benefit and take a little time, sort things out. And now they're going back. So as of September 27th, and indeed for a few people even before that, but let's just go with September 27th, people are going to be flipping back to EI as CERB winds down. So the most important changes are that it's just way easier to get on EI now. So as many of you will recall, EI used to be a sliding scale between 420 and 700 hours to get on regular benefits. For the special benefits, these are things like pregnancy, parental benefits, sickness benefits, the different caregiver benefits. It used to be a flat rate of 600. Well, for the next year or so, that's all out the window. It's 120 hours for everyone, everywhere, for everything. 120 hours is the threshold. And not only that, people who did not qualify for certain special benefits, pregnancy, parental benefits, or the various caregiver benefits last spring or summer, can actually now go back and qualify in effect retroactively. So what happened, a very sad but all too common story, was somebody might have been pregnant in April. April rolls around, they've worked about 400 hours, and now they lose their job. And so they're not actually eligible for their EI maternity benefits or parental benefits following. Now they can essentially go back and qualify that person for the special benefits they missed. the other key change is that the minimum EI rate is going to be $500 a week. So a lot of people remember who have attended my scintillating EI presentations. Generally, EI pays 55% of your average weekly earnings, possibly more for low-income people, but a lot of people would never get close to $500. But at least for the next year, claims starting in about the next year, $500 is going to be the floor. And on top of that, you're going to get at least 26 weeks of benefits if you qualify for EI. The mechanics of how they've done this are incredibly complicated, but I don't think you need to look behind the curtain for a lot of this. Just know that those are going to be the minimums. So there's a number of other EI changes. The period to collect the hours you need to get on EI is going to be extended if you got CERB. So a lot of people will remember that usually EI is going to look at your last 52 weeks. Could be shorter, could be longer, but that's the standard. If you've got CERB, if you're on CERB, they're going to give you an extra 28 weeks. So the easiest way to think about it is just that whole CERB period is just going to be cut out of the equation in a way. It's not exactly that, it's actually an extension, but what they're trying to do is compensate for those 28 weeks of CERB. So for most people who are transitioning from CERB to EI, you're going to get 52 plus 28, so 80 weeks back, which is quite a bit to collect your hours. Fishers, they're going to look back at your earnings possibly all the way back to 2018. So for fishers who had the season interrupted, there's going to be a way for them to qualify using earnings from past seasons, winter or summer. There's still no medical certificate or waiting period for sickness claims. And until October 25th, the waiting period is going to be waived for all other EI benefits. So I should go back a step. The waiting period for those who have some experience with EI, usually you have to serve 1 week without benefits when you make your claim. So you make your claim and then kind of the first week is on you. You've just kind of got to deal with it. And then you can start getting benefits in week 2. Well, until October 25th, there'll be no waiting period. So you can go right into getting your benefits. A lot of people I expect will be calling you with questions about the CERB to EI transition. How is this happening? I was getting CERB. I might have been eligible for EI. I'm not really sure what's going to happen. How am I going to get from the CERB program to EI? And like everything, the answer is it depends. So if we're going to look behind CERB, what we know is CERB is actually really 2 different benefits. For people who were covered by the EI system, it was paid through Service Canada as the EI emergency response benefit. For people who were not covered by the EI system, it was paid by the Canada Revenue Agency as the true CERB or Canada Emergency Response benefit. So if you're one of these people who had CERB paid through Service Canada, because when you filled out your application, you said you had been working a certain amount, so it's a good likelihood you have that connection to insurable employment or employment covered by EI. So if you got benefits through Service Canada, you should be automatically transferred to EI without having to reapply. As with all things in these benefits, I'm saying that is what should happen. That is not necessarily what will happen. So do keep an eye out for it. But the idea is that those people will be automatically transitioned to EI. I can already foresee a problem because one of the wrinkles is going to be that CERB did not necessarily require a record of employment. EI does require a record of employment. And all the employers were supposed to be filing ROEs for everyone like the requirement to file an ROE hasn't gone away because of the pandemic, but my guess is that there's a fair number of employers out there who didn't, and in fact may not be around to file it now. I can see that being a problem, and that's something you may want to keep tabs on, because it may be a problem clients are coming to you with. I can't, my employer didn't file an ROE, and I can't get them to do it. And we're going to be picking up and going into a lot of these topics in a lot more detail if you want to come to the EI CERB session on Thursday. But for our purposes today, just know that that could be a problem. And people who got CERB through CRA will likely need to apply for EI if they think they're eligible for EI. So, if someone hadn't done that much work, they might have filed for their CERB through CRA, gotten their CERB through CRA, but now with these new requirements may think, I might be EI eligible. Those people will likely need to reapply for EI now that that CERB is over. So the goal here is clearly to get a lot of people back into the EI system. But even with the easier access to the EI system, not everybody is going to be able to get into EI. The primary body of people who aren't going to qualify for EI are people who are purely self-employed. So people who only work for themselves and their business continues to be impacted by the pandemic. That was a large part of the reason why CERB came into existence in the first place. And while CERB is being phased out, they are bringing in new benefits to replace it that will hopefully target these people that are not covered by the employment insurance system. And there's 3 benefits, and they each do a bit of a different thing. They all start with Canada Recovery, and then the end of it tells you sort of what they do. The Canada Recovery benefit is the general one. I don't qualify for EI, but I'm still impacted. My work is still impacted by the pandemic, and we'll go a little bit more into what exactly that means. The Canada Recovery Sickness Benefit. So this is these are benefits for people who have or might have COVID, or who have to isolate, or are particularly susceptible to the impacts of COVID. There's now a benefit available. And also the Canada Recovery Caregiver Benefit. And this is for people who have to stay home to care for others, could be kids or family members who need care because they can't get their usual care as a result of COVID. And I should add at this point, while I say that generally these benefits are for people who are not covered by the EI system, that's not exactly the case. There may be people who are covered by EI, but they may need access to the Canada Recovery Sickness Benefit because for various reasons their time off work isn't covered by EI. Same with the caregiving. So although these are generally targeted to people who aren't covered by the EI system, there may be cases with the bottom 2 where people who are covered by the EI system could possibly find themselves collecting the bottom 2. So the general information on what you're going to get, all these benefits pay $500 a week. So everything is lined up. You can see the minimum payment for EI is $500 a week. The amount you're getting for all these benefits is $500 a week. So everything lines up to $500 a week, which was also what you were getting from CERB. So there's a fair amount of continuity there. The one difference people are going to note is that unlike CERB, tax is deducted from each payment. So you're probably not going to see $500. You're probably going to see $450 because there's going to be a tax deduction. The applications for the new recovery benefits are still going to go through the CRA My Account. So if someone has been set up for CERB, they're probably going to be set up for this as well. You can also do it by phone if computer isn't an option. And a bit like CERB, you are going to have to reapply each period, and we'll talk about what the periods are because they're a little different than CERB. And like CERB, it's going to be primarily based on your declaration that you meet the criteria. But I'm starting to get the sense that there could be, on a few claims, a little more front-end screening than there was with CERB. So it wouldn't surprise me if some people are getting asked for more information, but generally still the idea is that it's going to be declaration-based. The other difference that's not on here between CERB and the recovery benefits, CERB it paid in advance. You kind of got the money at the start of the period. For the recovery benefits, it's going to be paid at the end of the period. So kind of you wait the 2-week period and then you get your benefits at the end of it, which is why they're opening up now for the first period starting September 27th. The general requirements, you'll recognize a lot of these because they do line up with the requirements for CERB. You have to be resident and present in Canada. Again, that does not mean that you are a citizen or permanent resident. That's not a requirement. You just have to be, essentially have a home here and be here and be living here. You have to have a valid SIN. You have to be at least 15 years old. And you have to have earned at least $5,000 in 2019, 2020 in the new year or the last 12 months. So for those, again, that are familiar with CERB, these line up a lot. So the idea here is that most people who qualified for CERB are at least going to be in the front door for the new recovery benefits if they need them. So now I'll try to look at the specifics of the particular benefits. So the first is the Canada Recovery Benefit. So this is the general benefit for people who are still just impacted by their work is still just impacted by the pandemic. So what you will need to show is a reduction in earnings of at least 50%. Compared to your average weekly earnings before. So for example, if you qualify by saying, if your $5,000 were counted in the last 12 months, and in fact you had earned $52,000, making your average weekly earnings $1,000. Now you're only earning $250 a week. Well, you're going to meet that requirement because your average weekly earnings have fallen by 50% compared to your previous average. A big difference with CERB versus the Canada Recovery Benefits is there are now consequences and very serious consequences for not trying to get back to work. So it is a requirement to be looking for work to get the Canada Recovery Benefit. You will also be disqualified from getting any further benefits if you unreasonably quit your job or, in some cases, reduce your hours. You will also not get the benefit if you've placed undue restrictions on going back to work. And there can also be very serious consequences if you have refused a reasonable offer or reasonable opportunity to start working again. And this applies both to a job offer to go back working for someone else, or if you work for yourself, a reasonable opportunity to start working for yourself again. So assuming you qualify, you're going to get a maximum of 26 weeks. You cannot get while you're getting EI. So the idea here is you're getting EI or the Canada Recovery Benefit, but you're not getting both. So it's an either or for those weeks, and it's going to be paid in 2-week blocks, and you have to reapply each block. So the block that just and the earliest application date is the Monday after the block ends. So I don't have my calendar in front of me. I should have, but for the block running September 27th to I guess it would have been October 10th. applications opened yesterday, being the 12th. And so for the next 2-week block, once it ends, you can apply for that block on the following Monday. Okay, so now the Canada Recovery Sickness Benefit. So this is a benefit for people who, like it sounds, are sick, have COVID, might have COVID, but also for people who have to isolate or people who have to stay home because they have an underlying condition that puts them at greater risk if they contract COVID. This is not a Cadillac disability plan. You're getting 2 weeks and only 2 weeks max. And the test is that you cannot work for at least 50% of your usual work week. So if what happened to me today, the school just calls and says, come get your kid. Actually, this would actually be a better example for the next benefit. But if you only miss 1 day, you're not going to meet that requirement if you usually work 5 days a week. But if you miss 3 days and you usually work 5 days a week, then you're going to meet the requirement. It's not a general sickness benefit. It is just COVID related. That being said, many illnesses are going to have symptoms that it would be prudent for someone to stay home because of COVID, coughs, colds, flus, these kinds of things. So it'll be broad in that sense, but it is not a replacement. This is not a replacement for a general paid sick leave or short-term disability plan. On that note, you can't get it if you're getting paid sick leave, sick benefits, or WCB. So if you're getting paid through some other mechanism, you're not going to be able to get this benefit. And this benefit, it looks like they're going to pay it in 1 week blocks, not 2 week blocks. So the regular recovery benefit is going to be paid in 2 week blocks. This one, it looks like it's going to be paid in 1 week blocks, and you would apply the Monday after the week ends. So if you missed, if this week you missed 3 out of 5 days working, next Monday you could apply for benefits. And then the next one up is the Canada Recovery Caregiving Benefit. So this one is targeting situations where schools, care facilities, or other care is just not available to someone and they have to stay home because of that. So again, you just get a call from the school saying, your kid has a stomach ache, you got to come pick them up. You miss 1 day of work. That isn't going to cut it. You need to get a 50% reduction of your usual work week. So this is a bit of a buffer for those who have, or for your clients who have kids, if they have to shut schools, daycares, these kinds of things. It's also going to cover you if your kid or a family member you're caring for has COVID or might have COVID or has to isolate, or if they're at risk of serious health complications for COVID and therefore can't access schools or other care. The details are still a little bit vague, but it looks like for kids under 12, it's a given that they need care. For other family members, you will need to verify that the person actually needs care from you. And again, it's just going to be a declaration, and there isn't a huge amount of guidance on that now. But you could think of, if there's an older adult who, has home care, for example, and because of COVID can't access that care, your client has to stay home to provide the care. And as a result, misses more than 50% of their usual week. That might be the kind of thing that is that's covered. So the Canada Recovery Caregiving Benefit, it's a maximum of 26 weeks. 2 people in the same household can split the weeks, but only one person can get it each week, and the total can't exceed 20 weeks. So if there's a family unit, one partner can take 13 weeks, the other partner can take 13 weeks, as long as those 13 weeks don't overlap and they don't go above 26 weeks. And again, it looks like this one is going to be paid in 1 week blocks, and you have to reapply each block. So that is a very quick rundown of the new benefits. Again, if your interest is intrigued, then feel free to jump on. We're going to be doing a much deeper look at these benefits on Thursday. But I just trying to guess the kinds of things you're going to see and what your clients may be coming to you with. I think there'll be people coming looking for help applying. So again, helping people setting up CRA My accounts or using their existing CRA My account to apply. I can see some people needing some help hunting down ROEs, writing to employers. And then if you can't get the ROE, trying to deal with EI to get them to help get the ROE, or alternatively find another way to assess the claim. These new benefits will have, at the very least, a review procedure, a formal review if someone is denied. EI, of course, continues to have reconsideration and appeals. So I can see people coming for assistance with that. And it's almost a certainty that some people are going to be getting asked for more information. Again, it's still a declaration-based system where you attest that you meet the criteria, but it's sure starting to sound like, at least on a few claims, they're going to be doing a bit of a deeper dive. And so you may get people coming in saying, I've been asked for this and this and this, and I need some help responding. So that's a whirlwind overview of the new of EI and the new recovery benefits. And with that, we will pass it to Michelle and flip over to housing.
So I'm here today from TRAC. There is going to be a housing law update. Rob and Suzanne are going to be presenting on that later in the week. So I'm going to focus on the COVID-related changes to the RTA in particular. So there are some tenancies that are not covered under the RTA, and so none of the information that I'm about to present will pertain to those types of tenancies. The two, I can roughly divide them into two main types. They're non-RTA renters that could use the Civil Resolution Tribunal, hopefully, to resolve legal disputes, and those are mainly renters who are sharing a kitchen or bathroom with the owner of the property. Or people who are renting from another tenant. So the tenant in question is actually an occupant or a roommate rather than a RTA tenant, in vacation and travel accommodation. Or there are other situations like co-op housing or student housing or emergency shelters where people might have recourse to an internal appeal program or Supreme Court. The first thing I'm going to talk about is not COVID related. This was a private member's bill that came into effect at the end of May 2020, and essentially what it did was expand the criteria in which somebody could break a fixed term lease without penalty. So that was expanded. Initially, you could only do that because of, I think it was family violence specifically, or going into long-term care. So that's been expanded to include household violence generally. So a tenant could end a fixed term tenancy if they or an occupant or a dependent of either was the victim of violence that adversely affected their quiet enjoyment, security, safety, or physical well-being. So the RTB website has a pretty good summary of that new regulation. But essentially what a person would have to do is have their eligibility to end the tenancy confirmed by an authorized third-party verifier, and there's a specific form that's used. They still have to give the landlord a month's notice in writing. At the same time, they have to give the landlord that completed and signed fixed-term tenancy confirmation statement. So the form itself is this form here, RTB-49. And as it explains at the top of the form there in very tiny print, it's sections 39 and 40 of the residential tenancy regulation that specifies which professionals are authorized to sign this statement for people. So with respect to the other COVID-19 changes, I'm sure everyone is aware that the eviction moratorium has been lifted. So starting June 24th, non-rent related evictions were allowed. So there had been a blanket moratorium on evictions, but starting June 25th, I guess landlords could issue eviction notices for cause or 2 or 4 month notices for landlord use. Effective August 18th, so starting August 17th, the ban on evictions for unpaid rent was also lifted. So in practical terms, what that meant was that any tenant whose rent was due on or after August 18th could be evicted for unpaid rent from that date on. But for most people, that would have been September 1st. Most people don't pay their rent between the 18th and the beginning of the next month. So that means that people who were late to pay their rent on September 1st could have a 10-day notice issued. It also means that going forward, people could have evictions for cause for unpaid rent, or for repeated late payment of rent, setting off what they're calling affected rent. So people who didn't pay or got behind on their rent between March 18th and August 17th, eviction notices still can't be issued with respect to that rent payment period unless the landlord has provided a rent repayment plan and the tenant has fallen behind on that repayment plan. So I've just put in a link to the legislation governing that rent repayment program. It's COVID-19 regulation number 2. And that's sort of authorized under the COVID-19 Related Measures Act, which is also linked there. So, as I said, going forward, the ban on evictions for unpaid rent and utilities has been lifted. Tenants, starting essentially September 1st, expected to pay the rent in full and on time. And if tenants owed rent from the emergency period, which is defined by regulation as between March 18th and August 17th, then the landlord must provide a mandatory rent repayment plan, or basically lose the ability to evict based on that late or unpaid rent. So there is a helpful and detailed new RTB policy guideline on COVID-19 repayment plans and related measures. The link is there, and I think Lois has uploaded a PDF of this PowerPoint, so those links will be embedded in it. And again, the RTB website itself has kind of a helpful brief summary of what the repayment plan looks like. So in order to be able to evict for unpaid rent in that period, again, that by legislation, they're calling it affected rent. So that's rent that became overdue between mid-March and mid-August, effectively. So repayment plans have to include 4 basic terms. It has to end by July 10th, 2021. The repayment period starts when the repayment plan is served to the tenant. The overdue rent has to be paid in equal installments. Each installment has to be paid at the same time as the rent is due under the tenancy agreement. And the first installment has to be at least 30 days after the repayment period starts. So if a landlord was able to give a tenant a repayment plan on, before September 1st, it would be effective August 1st. So the rent repayment installment would be due on October 1st as well. So there are some variations that are allowed with these repayment plans, but only in limited ways. So a landlord can extend the repayment period, so they can make it longer than 10 months. They can't make it shorter. They can allow earlier installments to be lower than later installments, but they can't require that earlier installments be more. They either have to be equal or earlier installments have to be smaller. And they can change the date that installments are due, so long as the first installment is at least 30 days after the service of the notice. So in the example from earlier, if the repayment period started September 1st, the earliest installment could be required would be October 1st, but the landlord could extend that and say, okay, doesn't have to be paid until October 15th. So the repayment plans have to be in writing and they have to be properly served. And they have to be served basically in the same way that most documents have to be served under the RTA. It has to be either hand delivered or sent by registered mail to the tenant's address or to a forwarding mailing address provided by the tenant, or it can be as ordered by an arbitrator. So if somebody applies, I guess, for a substituted service order, then an arbitrator can determine how the repayment plan was to be served. So here's where we get into what happens now if a tenant is in default of the repayment plan. Essentially, they can be given a 10-day notice for non-payment. So if the next time the rent is due and the installment payment is due, if the tenant doesn't come up with all of that money, the rent and the repayment installment, they can be issued a 10-day notice for non-payment. It functions the same way as it would for rent. The tenant can cancel the notice by paying the outstanding amount within 5 days, or they can apply for dispute resolution within 5 days. As with unpaid rent, though, a tenant can apply for dispute resolution, but unless they've paid the rent within the 5 days, the arbitrator will essentially uphold that eviction unless the tenant can show that they thought they had authorization not to have paid it, either because they had an existing order from the branch or because they had to make some emergency repair and pay for that, and that they consider that counted towards the rent. So this is just a copy of the RTB's repayment plan document. It's 2 pages long. It's a bit confusing, honestly, if you ask me, but it's very detailed. It's got all the information that has to be there. I'll just go on to explain that a tenant can serve a repayment plan on a landlord as well. I can't really think of any circumstance in which that would be beneficial to a tenant unless it would be to replace an existing repayment plan that was less favorable. So part of this legislation is that if the landlord and tenant had already entered into a repayment agreement plan for some of that affected rent, then it could be supplanted or replaced by this new kind of legislated rent repayment scheme. So that it might be beneficial to a tenant in that case. If they had an agreement that said they had to repay all their rent within 3 months, then they could serve a new repayment plan on the landlord. It would replace that existing not favorable repayment agreement. The other kind of tricky issue with this repayment plan scheme is that there's no date by which a landlord has to provide this repayment plan. So we've been getting questions from people saying, like, you know, they owe a couple $1,000s in rent. Their landlord is bothering them to repay it. In some cases, people are saying they've asked their landlord for a repayment plan, they haven't received one. There's nothing precluding a landlord, at least from what we've been able to gather, from waiting until April 2021 and then serving a repayment plan that would require the tenant to repay all of their outstanding rent in 3 months, basically. So the only thing I can really think to suggest to people is if they're in that situation, if they have the means to be putting aside money against such a time as that happens. I'm not sure why that nothing was written in, why the legislation was written that way, essentially, rather than saying that a landlord has to provide 10 months from the date they issue a repayment plan to allow a tenant to repay it, rather than saying it can only go until June or July 2021 unless the landlord agrees to. So yeah, I mean, TRAC is concerned about how this repayment plan was formulated and the fact that rent increases are allowed effective December. We know that there are a lot of tenants in this crisis situation. We have had contact from media who'd be interested in talking to tenants. Many of whom, of course, don't want to go public and talk about this. But if anyone does have tenants who would be willing to do that kind of media, you can let them know to contact us. I'm trying to go really quickly because I'm mindful of the time and hoping that we'll have time for questions at the end. There's just a few more things apart from the rent repayment that are kind of COVID related. Initially, of course, during that first emergency period from the end of March to the end of June, landlords were not entitled to access tenants' units without explicit consent from the tenants. That was lifted at the end of June, and it's returned to the status quo, which is that landlords are entitled to come in with or without the tenant's consent, so long as they give proper notice, which is 24 hours in writing. This means that real estate showings can go ahead, that work can be done, monthly inspections can resume, and tenants don't have any recourse. Oddly, even if they're supposed to be in quarantine or they're self-isolating. It says on the RTB website that landlords are expected to practice recommended guidelines. So whatever, I guess, Dr. Henry is recommending at the time. So a tenant should be able to ask that a landlord comply with social distance measures and masks and gloves, but there's nothing actually, there's no enforcement mechanism to make sure that that takes place. Conversely, tenants are still limited by legislation in the sense that landlords can still set restrictions on common areas. So landlords can still make rules about shared spaces like laundry rooms. They could still restrict access to common rooms, rec rooms, or gyms. And tenants won't be entitled to any kind of rent reduction because their access to those spaces has been limited or restricted. Landlords still can't and couldn't restrict tenants' guests from accessing tenants' rental unit, although that did happen quite a bit. We did get a lot of people, tenants being told that they couldn't have friends or caregivers or whoever attend at their unit because the landlord determined it was a health risk. Rent increases, there had been a freeze on rent increases. So typically landlords, of course, can raise the rent every 12 months by an amount determined by regulation. There was a rent increase moratorium that was announced on March 30th, such that any rent increase notices which were to take effect on or after April 1st were suspended. That moratorium was lifted and those rent increases can take effect as of December 1st, 2020. The rent increase limit was set to 1.4% for 2021. So any kind of new rent increase notices that were issued that were to take effect starting January can only be 1.4%. As usual, a rent increase notice has to be given 3 full months in advance on an approved form. There were some changes by regulation to document service regulations. Those were lifted as of June 24th. So for a while, in-person service was suspended and service by email was allowed, which was very convenient and much safer. And the RTB did say when they lifted that email service provision that it would be reinstated. They hoped to have something worked out by September. That still hasn't happened, so people are now limited again to serving either in person or by registered mail or the other approved service methods. It may be easier to obtain a substituted service order due to COVID. So if you have tenants who have compromised immunity or for other reasons are less able to serve documents in person, they may be able to get an order for email service more easily. I'm not sure, we haven't seen all of that. Again, while the eviction ban moratorium was in place, it wasn't possible for landlords to obtain writs of possession based on orders of possession. As of July 1st, that was lifted and landlords could resume enforcement of OPs through the Supreme Court, and the court-approved bailiffs were again resuming enforcement of the writs of possession. So I mention illegal lockouts just because this has been an ongoing issue through, well, before COVID, but through the COVID period and beyond. The Compliance and Enforcement Unit is available to intervene in illegal lockouts. So in situations where a landlord doesn't have a writ of possession or even an order of possession or is trying to lock a tenant out, the compliance and enforcement application form is available online. There are, as I understand it, only 4 compliance and enforcement investigators, staff members. So there are not very many, and they may or may not be able to intervene. Technically, I think they don't like to intervene unless the tenant has already filed. So for instance, a tenant who's been threatened to be locked out or has been locked out by their landlord should file for the RTB for an expedited hearing for an order of possession. But I have had cases where the CEU has, intervened and contacted landlords even though the tenant hadn't filed for an order yet. The other thing that's happened is until June 24th, there was a practice directive that was in effect, directing arbitrators to kind of consider COVID-related circumstances for extending timelines and deadlines and for adjourning hearings. And that practice directive was rescinded on June 24th. It is supposed to still be applied to circumstances that arose before that date. And going forward, the RTB is still supposed to assess those kinds of requests for extensions or adjournments on a case-by-case basis. But there's just more of an onus on the applicant to show that they, are have compromised health conditions or that they have specific circumstances that would kind of enable an arbitrator to exercise their discretion in that way. Again, you can reach out to TRAC if you have tenants who are experiencing access to justice issues. And the new housing law clinic is doing judicial reviews at Supreme Court for issues related to evictions, but other residential tenancy issues as well. That's it. I really flew through that presentation. So we do have, looks like a few minutes left for questions.
So as it turns out, I think Kevin and Allison have answered questions in writing.
Perfect.
Allison or Kevin, are there any that you want to comment more on?
The only thing I forgot to say, and I realized I totally forgot to say it, is sorry, this is going a little off topic. The recovery benefits. If someone earns more than $38,000 in the tax year, either in 2019 or 2020, you'll have to repay 50 cents on the dollar above that amount. So if someone's taxable income for 2019 is $40,000, they'll have to repay $1,000, but that'll be taken care of at tax time.
There's a couple of other questions, guys. Oh, no, just someone saying thank you.
And sorry, one more thing, Lois? Sorry, I'm remembering everything I forgot to say. Some of you, with all these new federal benefits coming online, we're trying to evaluate sort of ongoing what kind of supports people need for EI, CERB, the recovery benefits. So if you see a random survey pop into your mailbox from class, it would be really helpful if you could just give us some indication of sort of what EI and federal benefit services you are providing, because we're trying to figure out, all the stuff is coming so fast. So we're just trying to figure out how to best support people. So any information you could give would be much appreciated.
So I think that's it, everyone. Thank you again for turning up. Sorry I was so disorganized at the start, but I think we've covered everything off. So thank you, everyone. We'll see you soon.